Hi, I'm Alex and I'm back with you for another video on high conflict child custody. This video is going to be on contempt of court. So this is going to happen. You're going to go to court, you're going to do your research, you're going to do everything right, you're going to win your case, and then after that you're going to find that your ex might not comply with the court's order. And this can be very frustrating because court's already an extremely expensive process, whether you're paying with your money or your time. And for you to go through the entire process and then win your case and have an order in your favor and have that order be ignored, it's going to be extremely frustrating. Now, if you're in a high conflict child custody dispute, this is not an issue that's going to go away by you being nice. So you're going to end up having to move for something called an order to show cause. In other states, this could be a different process and it could be a simple process, but I'm going to go off of Nevada because that's where I am. So keep in mind that anything I'm telling you is consistent with Nevada law, so you may have to research your own state and actually look in and see if everything is either the same or different. So in Nevada, when somebody violates a court order and you want to have that order enforced, you need to do something called a motion for order to show cause. And what you're asking the court to do is to order your ex to come back in front of the court and explain why she should or should not be held in contempt of court. So there's two types of contempt of court. Now, the most common is contempt of court in the immediate presence of the judge, and most people understand what this is. This is where you're in court and you're mouthing off or you're acting disruptive in some way. This kind of contempt of court is pretty simple. The judge will just order you arrested or fined, and it's pretty much done then and there. This isn't what happens in child custody cases usually. What happens is the judge will enter an order and then your ex will violate the order outside of the presence of the court. And this is much more complicated because the judge didn't see anything. And there's also a whole lot of procedure that comes into play. It's not just done at the snap of a finger. So you're going to need to research your state statutes and your state laws, because aside from asking the court to order your ex to appear and show cause, there tends to be other technical requirements. For example, in Nevada, you have to include something called an affidavit with your motion outlining specifically what your ex did and how she violated the court order. It's not so simple as to just state it in the motion. Affidavits have to be done under oath. Typically a notary has to put their stamp on it, and you have to go through this process. So don't think you can just really quickly file this motion and have it taken care of, because if you may be in the right and your ex did violate the order, but because you failed to follow some procedure, the judge will deny the motion. And this is even more frustrating because it'll seem to you like the court just doesn't care that they're violating their orders, which is just not the case. You just didn't follow the law. So once you understand that you're trying to hold your ex in contempt of court for conduct outside of the presence of the court, and you start doing your research, you're going to have to look into certain things that are relevant to contempt of court. So for example, in Nevada, there's two types of punishment for contempt. I'm going to try to be really general here, but you're going to have to find the details out on your own. One of them is called civil contempt, and one of them is called a criminal contempt. The type of contempt you're asking for is going to depend on what you're asking the court to do. So a civil contempt is a contempt of court where you're asking the court to force your ex or to coerce your ex into doing something she's supposed to do. And civil principles will apply, and basically what it comes down to is your ex will be imprisoned until she complies with the order of the court. Another term they use is the contender holds the keys to their own jail cell in their pocket, which is basically saying it's up to them when they get out. All they have to do is comply with the court's order. This is usually not the type of contempt you're going to do. This is for somebody who may have been ordered to, for example, sign over a title to a house and they refuse to do so. Then they can be imprisoned until they sign over the title, and then they're released. Most common, it's the other one. It's criminal contempt. This is the contempt of court that applies not when you're trying to coerce your ex into doing something she should have done consistent with the court's orders, but where you're trying to get the court to punish your ex for doing something that she should have not done. And this is what's going to come into play when there really is no no conduct that you're there to coerce, at least not in the immediate sense. So for example, you were supposed to have the children for a Christmas visit and your ex simply didn't bring them over to you. I mean, you can't really coerce that conduct. That's already come and gone. The vacation has come, she didn't show up with the kids, and you didn't get your kids for your visitation period, and now it's over. So that's not a civil contempt. What you're trying to do there is a criminal contempt, which is you're trying to punish them for violating the court's orders, and the purpose of that is to deter them from doing it in the future. For this one, criminal principles will apply. It's a different standard of proof. It's beyond a reasonable doubt. And there are a few other hairy things. They might be entitled to counsel. They aren't necessarily automatically entitled, but they might be. And there's another big one. The punishments are more limited by statute, at least they are in Nevada. Whereas in a civil contempt, they can be jailed until they comply indefinitely. With the criminal contempt, if they're held in contempt of court, the court is bound to, at least in Nevada, a $500 fine and 25 days imprisonment, or both, but they cannot exceed that. So what you're going to have to do is going to be a lot trickier than it seems. A lot of people, especially when they're in high conflict child custody cases, they want to get revenge and they want to punish their ex, and a lot of them would love nothing more than to see their ex carted off to jail. And the courts know this, and it happens very frequently that unrepresented parties file these motions trying to have their exes jailed for frivolous reasons. And so you're going to have to stand out. This is going to really depend on what your ex has done to violate the court's order. For something really major, for example, like the Christmas visit, that's a pretty huge deal. Depriving you of a Christmas visit is a huge enough deal that they do it one time and you can take it to the court's attention and you'll probably get some kind of success or some kind of punishment. But in high conflict child custody cases, sometimes you'll have an ex that doesn't really want to do anything on a massive scale to frustrate the court, but they do a lot of small little things. And the way you go about bringing those to the court's attention is different. There's more of a process to it. So in my case, the example I'm going to use is turning over my son's homework packets. My ex was under orders to exchange a homework packet every time we exchange our child. And she just wouldn't do it. And sometimes she would, sometimes she wouldn't. But it was enough that it was disruptive to his schedule. And I realized you could try to modify custody on this, and that's just really going to have to be a separate issue. What I'm going to focus now on is contempt of court, which is what I focused on. What you have to do with these small issues is make sure it's enough of an infraction that you can show the court that this is something that continues to happen over and over again, and that even when it happens, you give your ex an opportunity to rectify it. So what I'm trying to say is you don't want to say, haha, you didn't give me the homework packet, now I'm going to put you in jail. You don't want to do that because it's not going to work. What you want to do is say, look, I didn't get the homework packet. Why don't you find another way to get it to me within a few hours or tomorrow, drop it off, give them some options to work around their violation. Because if you go to court and you show them, not only did my ex violate the order repeatedly, but I gave them numerous opportunities to rectify the situation, the judge is going to see that you're different. You're not somebody who's just trying to put their ex in jail. You're trying to do everything but, and this is a last resort. And this is what I did, and it worked. And I went to court unrepresented without an attorney, and she had an attorney, and she still got held in contempt of court and ordered imprisoned. So this can happen. You just have to go about it in a very sensible, logical way. One of the other big things is sometimes your ex will violate a court's order, but it really doesn't have any impact on you. If this happens, you should just let it slide. I don't have any good examples right now, but think about it. Is this order being violated? Has the violation happened more than once? Is the violation even causing me any stress? And have I given my ex an opportunity to fix the issue? If all four of these things line up, then go ahead and do it. But if they don't, you really should just let it slide, because you can only go to court on an order to show cause so many times before the judge just stops listening to you. So you want to make sure that when you go to court, you have an airtight case, and that you have as much evidence as possible and as many witnesses as possible, and so that you succeed. Because like I said, if you fail, coming back again the next time, they're just going to point out and say, look, he's tried to do this before and he's just trying to harass us. So keep that in mind. If you do use an attorney, at least in Nevada, you're entitled to attorney's fees if you win. This is different from the ordinary child custody attorney's fees laws, because really usually they have to show that you are harassing them, which involves not only losing your motions or your case, but also demonstrating that you had no legal basis for your whatever claims you brought to the court's attention. With contempt of court, you just automatically get an award of attorney's fees if you can establish, if you win your contempt of court motion. So keep that in mind. As far as the punishment for contempt, in my experience, the judge will ask you what, it's called what's the sanction? What sanction do you want to impose on your ex? So when you win your hearing and your judge says, I find you in contempt of court, he might just issue this, he might just sentence them right then and there. Or he might ask you what you think the sentence should be. In my experience, if it's a high conflict child custody matter and your ex already has an attorney, they're already paying money. They're already, you know, forking over money hand over fist to frustrate your life. A sanction of a fine is really not going to deter them. In my opinion, in this kind of situation, if it's their first infraction and the judge is leaning towards a fine and their attorney will usually ask for a fine, tell the court, you know, this is a situation where we're already spending a lot of money. She's already got an attorney. She's already spending money. Money doesn't seem to deter her. Please put her in jail for at least 1 day, especially if it's their first infraction. I mean, don't come right out of the gate swinging saying, you know, I want my ex to go to jail for 25 days. Unless this is a situation that's completely insane, where maybe they just kept your kids from you and haven't given them back to you for 9 months. And I mean, that's a different situation. But for small issues like the homework packet, this is something that I did. I told the court I would have preferred imposition of a 1-day imprisonment over any amount of money because she was already paying tons of money and she didn't seem to care. So keep that in mind. It does sound like it's a little mean, but sometimes you're just going to have to put your foot down and tell, you know, to show your ex that when the court makes decisions and those decisions are in your favor, they need to be complied with, because if not, they're going to go to jail. And I did this and it did work. I'm not going to say it worked 100% because I did end up having to go back to court and modify custody and terminate her parental rights and all that. But you know, this is a different, you know, this is a step in the process. This is a step where you're saying, I've won, and I'm not going to let you just ignore the orders of the court. I'm going to hold you to them. Obviously, if you have to go back to court for contempt again 2 or 3 times, you're going to ask for a larger sanction. You know, 2 weeks in jail, 25 days in jail. I didn't have to do this because, I mean, like I mentioned, I just terminated her parental rights. But in your situation may be different. You may have a more protracted process. So with that, I'm going to end this video, and thank you.